Item 48.
After some time.
For motion, item 1.
May please your lordship, prayer for regular bail who was arrested on 4th February 2026 in connection with the instant case at Maheshwar Police Station, Vaisali, Bihar. He was produced before the Court of Chief Judicial Magistrate. Lordship, kindly see para 11, page number 7.
You come to page number 2.
Para 11, page number 7.
No. You come to page number 2.
Page
Number 2 of your petition.
number.
Got it.
Mm.
You see, you read it.
Session special case number 65 of 2020 under section 87 BNS, read with section 6 of POCSO Act.
Is the word POCSO there?
Yes.
Where?
I think typing mistake.
Typing mistake. Okay, issue notice and call for the record.
Lordship,
Place the matter on.
issue notice to the opposing.
Pardon?
Issue notice to the opposing sides.
Yes. Respondent number 2. Correct.
Number is 5026 29.
This year.
25th August. Kindly withdrawal, item 48.
Yes.
Lordship, this petitioner wants to withdraw this preliminary petition, Lordship.
Your name?
On behalf of S. Nyogi, Your Lordship.
Your name?
R.R. Gogoi.
R.R.
Gogoi. On behalf of S. Nyogi.
R.R. Gogoi, Learned Counsel appearing on behalf of Mr. S. Neugi.
Nyogi.
Learned conducting counsel for the petitioner submits that he has the instruction to withdraw this petition. We are allowed. This criminal petition number so and so stands a disposal of withdrawal. Liberty will be required. Not
Liberty
necessary.
Okay.
Item 2.
May it please report my names.
Yeah.
Today I'm asking for an extension and adjournment in this matter. The senior conducting counsel.
Extension of
Adjournment in this matter, my lords.
Call for the case there minus 18, similar to one minus yesterday the series. Another accused. 18 minutes there for income.
okay.
I'll give
18.
On
Okay.
18.
18 CD.
May it please on topic. Regular bail application matters. FIR is at page number 23. Intermediate quantity matter. And matter the petitioner has completed already 97 days. Charge sheet has also been submitted. Matter he is willing to face trial. Matter.
Yes, Mr. Portaker.
119 numbers of Yaba tablet. Intermediate quantity.
Heard Mr. Das, Learned Counsel for the accused, and Mr. Portaker, Learned Additional PP for the state respondent. This application under section 483 of the BNSS 2023 is preferred by accused Jabir Mia, who has been languishing in jail in connection with special NDPS case number 41 of 2026, arising out of Barpeta PS case number 149 of 2026 under section 20, which will get B of the NDPS Act. NDPS Act for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by SI Bijit Roy of Barpeta Police Station on 7/5/2026. The allegation against the present accused person is that he was found in possession of 119 numbers of Yaba tablet weighing 12.96 grams on 6/5/2026 at about 7:39 PM. At Zutigaon in front of the Borpeta Medical College Hospital, Borpeta. Mr. Das learned counsel for the accused submits that the accused was arrested on 7/5, apprehended on 6/5/2026, and he was remanded to Jail Azut on 7/5/2026, and since then he has been languishing in Jail Azut for last how many days?
97 days, madam.
97
7.
days, and that the quantity of contraband substance so recovered from the possession of the accused is of intermediate quantity. It is 12.96 grams, and that search sheet has been submitted by the IO after completion of investigation, and as such, the question of hampering investigation or tampering witnesses does not arise, and that the accused is ready to face trial and will appear before the learned trial court on each and every date, and therefore he has contacted to allow this petition. Mr. Borthakur, learned additional PP, has however opposed the petition on the ground that 119 numbers of Yaba tablet weighing 12.96 gram was recovered from the possession of the accused. How many accused are there?
One only, madam. Sold.
Having heard the submission of learned counsel for both the parties in this court has carefully gone to the petition and the documents placed on record, and also perused the materials placed on record. It appears that the accused was apprehended on 6/5/2026. While he was in possession of 119 numbers of Yaba tablet weighing 12.96 gram in front of Borpeta Medical College Hospital. At about 7:39 PM. 39 PM. Admittedly, the quantity of contraband substance so recovered from the possession of the accused is of commercial intermediate quantity, and investigation has already been completed, and now trial will start, and the accused has to prepare his defense. Considering the aforementioned facts and circumstances, further custodial detention of the accused seems to be not warranted here in this case, and accordingly this court is inclined to allow this petition. It's provided that on furnishing a bond of rupees 20,000 with 1 security of life amount to the satisfaction of the learned special judge NDPS Borpeta, the accused be enlarged on bail. Borpeta or Pachala?
Borpeta, madam.
Number 4.
Highly obliged.
May I please, Lord? The regular bail application, my lord. Page number 16, my lord. At this stage, my lord, city may be called for. City may be called for, my lord.
Borthakur, CDN
21. My lord.
21.
Problem. Maybe those.
Because the case is registered under section 4 POCSO Act and lower court proceedings goes.
Sarcited case or
Yes, madam.
is it sarcited case?
Sarcited case, madam. Lower court proceedings going on.
Where it is pending now?
Lakhimpur, madam.
Now,
Lakhimpur.
Lakhimpur.
madam. This is Lakhimpur.
Okay, Lakhimpur.
And accused was arrested on
Issue notice to the respondent.
2025.
Number 2. And also call for the TCR from the Court of Learned Special Judge POCSO, not Lakhimpur.
Hello.
Fixing the matter on
On 25th of
25th of August.
Right.
Item 6.
Wait. The NDPS intermediate quantity, at this stage, kindly the case diary may be called for
Yes, there.
from Murajar police station. Vajay,
Murazar PS.
Murajar PS.
When he was arrested?
On 10th of June 2020, 64 days behind the bar, Your Lordship. 27A has been.
27A. What is the punishment?
According the,
No, what is the punishment?
yes, the 37 has to be satisfied in case of
27A.
27.
CD on
24. Deeply obliged.
The CD may be called for and similar matter fixed on 20.
CD call for.
Oh, yes.
In that matter, CD was called for.
It is called for.
Okay. CD on
20.
28. 20.
Yes.
Number was.
What is the number of that case?
The AB number 1820 of the 2026.
Mr. Ahmed, learned counsel for the accused submits that in connection with AB number,
1820 of the 2026.
CD has already been called for, fixing the matter on 20th of August 2026. And on that day, CD may be perused to dispose of the present application also. Accordingly, it is provided that Resist shall take this matter along with AB number so and so and list it on 20th. And on that day, an endeavor will be made to dispose of this petition after perusing the case date. Next.
Item 8.
Yes.
Here is bail application, Lordship will find FIR at page 10, my lord. Page 10 is the FIR, my lord.
Incident occurred in ESIC hospital. On that day, the incident regarding ESIC hospital, he is also a security guard.
In this connection, my lord has already granted some person, my lord. They were arrested, my lord. He is not arrested, my lord. He is a security person, my lord, ex-serviceman, my lord. Lordship will find at page 18, your lordship order is there, my lord. Page 18. My lord, he has been called.
Let us dispose of this matter today then.
Yes.
Where is the order?
Page 18, my lord.
Is it? Page 18. Similar order. Okay.
This is the previous, my lord. Obligement.
In the condition provided. Last second.
Nine, for respondent number 2, the in this case, notice may go to the respondent number 2.
Can here.
Can scan copy earlier call for.
Wrongly listed for. Is here also notice.
Okay. Third, Mr.
SRN asset.
Learned counsel for the petitioner and Mr. Bortaku, learned additional PP for the state response. Office note dated 10/8/2026 indicates that trial court record has not yet been received. Accordingly, it is provided that Resist shall issue urgent reminder to the learned trial court for transmitting the session, scan copy of the session. Not a scan copy, it is a dispose of matter there.
Lordship pending.
Session T1, case number 14 of 2024.
The framing of charges.
This is against a search framing order.
Here's the charge.
The learned counsel for the petitioner has pointed it out that notice is required to be issued to the respondent number 2, and till that no notice has been issued. Accordingly, it is provided that notice be issued to the respondent number 2 by speed post and also by usual process within a week from today. List after list on COVID. Fixed that
On 27th.
27th of
Deeply obliged.
Item 10.
returnable after forest colony.
And perhaps this matter will come up on admission, my lord. Just again come as a motion. Perhaps because of notice is not issued, my lord. PCR has been called for, my lord, in earlier date.
Okay. Heard Mr. Hussain, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. Office note dated 10/8/2026 indicates that PRC case number 502 of 2026 has not yet been received from the Court of Learned Additional Chief Judicial Magistrate Kamrup Aminggaon. Accordingly, it is provided that rest shall issue urgent reminder to the Learned Additional Chief Judicial Magistrate Kamrup Aminggaon for transmitting the PRC case number 502 of 2026. And list the matter on
27 August.
My lord.
10, 11.
This revision is against the judgment and order dated 22/8/2025. Passing criminal appeal number 21 by the Learned Additional Session Judge Udalguri, whereby the judgment and order passed in Learned Trial Court dated 2/8/24 has been affirmed. Lordship may take note of the first judgment of the Learned Trial Court below, which is at page 19. My lord. In relation to the commission of offense under section 354A, 1 year willful imprisonment has been imposed, and so for the commission of offense under section 341, 1 month imprisonment has been imposed.
under
According-
section 354A.
354A, maximum punishment is 3 years, my lord. 1 year punishment imprisonment
Imposed.
imposed, my lord.
The
Maximum
person
3
is
years,
behind the bar or he is on bail?
my lord.
Person is behind the bar.
Yes, behind the bar. My lord. He was arrested on 25/2026, my lord. What happened in this case, my lord? So, as many as my lord. 12 witnesses have been examined, except the PW 1 and 2. All are my lord hearsay evidence, my lord. And so for the IO part is concerned, that is my lord. Keeping aside. Now, what happened, my lord? So for the statement of 1 and 2 is concerned, 2 is the my lord victim, my lord. And as per the statement of PW2, the PW1, so for the allegation is concerned, while the PW2 was gagged by the present petitioner, my lord, the PW1 ran towards her aunt's house. It is the statement of the PW2. And the PW1 says that at the relevant time, I tried to save PW2. Now, aunt's the distance between the place of occurrence and the aunt's house is 5 minutes walking.
Okay, let notice go at this instance. Let the record come.
Record.
I will be considered after appearance of the respondent number 2.
My lord, so far, my lord, 1 year imprisonment, already, my lord, 2 months had passed, my lord. So far,
Maybe.
bail part is concerned, my lord. May it be, my lord, possible, my lord, before, my lord.
But notice has to be issued to the respondent number 2.
So far, that part is concerned, my lord, I am not objecting, my lord. So far, my lord, releasing the petition on bail, my lord. Because, my lord, releasing the bail, my lord, petition on bail, my lord, the matter will not end. Lordship is very much.
Pardon?
So for the release of the petitioner on bail, my lord, matter will not end. It will be subject to his bail will always be subject to the decision of this, my lord, petition.
No, that's
If it is
but,
not a
but
dismissal, again, my lord, put behind the bar, my lord.
in the event of availability of the record on next date, we will consider it. We'll see.
otherwise, madam, 1 year imprisonment already, madam, so far the offense in relation to madam 341 is concerned, already 1 month has been passed, madam. Would that, would
No, in respect of 354,
1 year, madam, maximum?
no, that's all right.
Yes, madam. No, my submission, you will not see, because he is, madam, in not such a position to evade from the proceeding, madam.
No,
He will not, madam, abscond from the, madam, proceeding, madam, nor he will, madam, leave the, his original, madam. Considering the, madam,
two,
maximum.
two
period of
courts has
punishment,
convicted you.
madam.
So the presumption of innocence is now not available to you.
Well, I admit, madam. So far, the decision of the two courts below, madam.
Heard
That's true, madam.
Mr. Sharma, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. This petition under section 422 of the BNSS 2023, read with section 438 of the BNSS 2023 is preferred by the petitioner, namely Mukunda Manki. Mukunda Manki, challenging the judgment and order dated 22nd/8/2025 passed by the learned additional session judge Udalguri in criminal appeal number 21 of 2024. It is to be noted here that by impugn judgment and order dated 22nd of August 2025, the learned appellate court has affirmed the judgment and order dated 2nd of August 2024 passed by the learned Aziz and S. Udalguri in PRC case number 566 of 2022 under section 341, 354, stroke 354A, Roman 1 of IPC. And affirm the judgment and order of conviction and sentence passed by the learned trial court. It is also to be noted here that the learned trial court by impugn judgment and order dated 2nd of August 2024 has convicted the appellant under section 341, 354, 354A, Roman 1 of the IPC and sentenced him to suffer rigorous imprisonment for 1 year for the offense under section 354A, Roman 1 and SI for 1 month under section 341 IPC. Peruse the petition and the documents placed on record and also peruse the impugn judgment and order dated 22nd of August 2025 passed by the learned appellate court and also the judgment and order dated 2/8/2024 passed by the learned trial court in PRC case number so and so under section so and so. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. But extra requisite copy of the petition be furnished to him during the course of the day. The SSL call for the records from the learned trial court as well as learned appellate court and list the matter on copy fixated.
On 14th September.
In I also issue notice. Right. To the informed.
Obliged.
Last matter may be passed over for time being.
Well, my lord, there is listed for motion, my lord. TCR call for earlier, my lord, TCR received. There is, my lord, passing on the FIR. We come up for admission. In any subject matter. TCR already received.
The interim peer is there. Okay, let her counsel. Here. Appear.
Item 14.
May it please to your lordship, kindly matter may be passed over for time being.
15, you know, 15 there, 14, 15. Obliged.
16.
Net preservation. My lord, by page 13, my Jimma petition was allowed, my lord. My lord will find the conditions was given to obtain a bank guarantee, my lord. I'm a very poor man, my lord. Bank guarantee of 5 lakhs rupees, my lord. And then thereafter, I have prepared a replication. Learned session judge has modified the order, page 18, my lord. Instead of 5 lakh bank guarantee, my lord, reduced to the extent of 2 lakh rupees and 3 lakh rupees shall furnish a bond of remaining amount 3 lakhs rupees, my lord. My financial constraint, my lord, I am ready to, my lord, furnish, my lord, but I thought, because this was the only car, my lord, it was under cattle preservation, my lord. So my respectful prayer, my lord, instead of this, my lord's huge financial bond and sureties, my lord, my respectful prayer will be, my lord, to allow this petition on personal
Under which provision the case was registered?
prevention of cattle preservation, my lord.
Cattle preservation.
Page 22, my lord. Page 13.1. By page 13, learned Chief Judicial Magistrate has also observed that I was not the accused, my lord. My car was used, my lord. If this was the only source of income through which, my lord, I was maintaining my family, my lord. Instead of this,
Where is the Zimmer list? Oh, sorry, Caesar list?
Caesar list, my lord, will find at page 24, my lord.
24. That is in respect of the cattle. In respect of the vehicle, where is the Caesar list?
Page 23 and 24, my lord.
What is the value of the said vehicle?
Vehicle was, my lord, it was a second-hand car that I have purchased, my lord. That time, my lord will find my registrations details in page 25, my lord.
Where is the insurance certificate?
Insurance certificate, my lord, we have not.
What is the insurance certificate? We'll see. What is the value of the vehicle?
By bringing an additional affidavit, my lord. Next week, any date, my lord, as per the convenience. The initial order was passed on 7/5/26, my lord.
Heard Mr. Tapader, learned counsel for the petitioner, and Mr. Borthakur, learned additional PP for the state respondent. In this petition under Section 528 of the BNSS 2023, read with Section 503. And Article 227 of the Constitution of India, the petitioner has challenged the order dated 28/6/2026 passed by the learned session judge Vishwanath. Mr. Tapader, learned counsel for the petitioner, submits that the petitioner is the registered owner of a vehicle bearing number ES01MC 8966, which was seized by police in connection with Jinjia PS case number 24 of 2026 on 15/4/2026. Under the Assam Cattle Preservation Act 2021. Thereafter, the petitioner has filed one application before the learned judicial magistrate first class necessarily seeking custody of the vehicle, and the learned magistrate by order dated 7/5/2026 has allowed the petition subject to furnishing of bank guarantee of rupees 5 lakhs. Mr. Tapader further submits that the financial condition of the petitioner is not good, for which he is unable to furnish bank guarantee of rupees 5 lakhs, and therefore he has preferred one revision petition against the order dated 7/5/2026 before the learned session judge Vishwanath, and by order dated 28/6/2026, the session judge has modified the order and directed the petitioner to furnish bank guarantee of rupees 2 lakhs. What is this? 5 lakhs to 2 lakhs and further directed to furnish surety bond for remaining amount of rupees 3 lakhs. Okay. 3 lakhs. And further directed to furnish surety bond for remaining amount of rupees 3 lakhs. But Mr. Tapatar submits that the petitioner is not in a position to furnish the aforementioned bank guarantee of rupees 2 lakhs. And being aggrieved, he approached this court by filing the present petition. To a query of this court, Mr. Tapatar submits that he has not enclosed the insurance certificate of the vehicle with this petition. In order to ascertain the value of the vehicle and also to consider the conditions so imposed by the learned courts below, this court is of the view that perusal of the insurance certificate of the vehicle is very much necessary. And accordingly, Mr. Tapatar is directed to bring on record the insurance certificate of the vehicle by filing an additional affidavit on 24 hours.
Obliged.
Please, Your Lordship. Lordship, it's an application under section 528 of BNSS for quashing the proceeding pending at Honorable JMFC Hajo, White PRC case number 491/26 under section 87 and sursit. Lordship, on 24th April 26, one Rezi Sultana lodged an FIR against me at Dodora outpost under Hajo PS to the effect that on 23rd April 26 at about 7:30 p.m., the minor daughter of the informant, namely Raina Sofin, aged about 14 years, went missing from the home. Later, it was learned that the alleged accused person, by inducing the victim, kidnapped her. Hence the case, Lordship. After the case, police surseated the case against me, and the proceeding is pending right now on the Honorable JMFC Hajo. So after that, both the party mutually settled the case. They are very same locality, nearby home. So they told that there is some misunderstanding. So they amicably settled this case.
What is the age of the victim?
Compromise, Lordship, compromise agreement is there in the page number 31.
What is the age of the victim?
14 years, Lordship.
Charge is submitted under section
87, yes,
87.
87.
But there are two decisions. One is a Narendra Singh and another is Gyan Singh.
Lordship.
So whether this case fall in the parameters laid down in those two cases.
Lordship. Because in some POCSO cases also quashed by Honorable High Court and Honorable Supreme Court. Lot of cases, there are some decisions. So I have put some decisions here. Lordship, I'll show some. One is Gyan Singh, Lordship.
Yes.
It has been held that when the parties have reached the settlement and on that basis petition for quashing the criminal proceeding is filed, the guiding factor in such cases would be to secure end of justice, and second, to prevent abuse of the process of any court. While exercising the power of the High Court, it is to form an opinion on either of the process of aforesaid two objective. Again, one decision is there, Kapil Gupta versus State of and City of Delhi. Lordship. In this case, it was under 376 actually. So it is held that in this case, that if the informant victim herself is not supporting the prosecution case, even if the criminal trial is permitted to go ahead, it will end in nothing else than an acquittal. If the request of the parties is denied, it will be amounting to only adding one more criminal case to the already overburdened criminal courts.
Okay, let us call for the record. On next date, we will see.
That's it.
Heard Mr. S. Chaudhary, learned counsel for the petitioner. In this petition under section 528 of the BNSS 2023, the petitioner has tried for quashing the entire proceeding of PRC case number 491 of 2026 under section 87 BNS 2023. And the search sheet being Hazu PS case number Hazu PS search sheet number 154 of 2026 arising out of Hazu PS case number 151 of 2026. Mr. Chaudhary, learned counsel for the petitioner, submits that due to some misunderstanding, the informant has lodged the FIR against the petitioner hearing. Against the petitioner hearing, and after investigation, police submitted search sheet against the petitioner before the Court of Learned Judicial Magistrate First Class Hazu under section 87 of the BNS, and now the case is pending before the said court. And in the meantime, both the parties have settled the dispute, and they have also executed one deed of compromise dated 15th of July 2026, which is annexed with the petition as annexure number 3. And on the basis of aforesaid compromise deed, Mr. Chaudhary submits that the proceeding of PRC case number 491 of 2026 under section 87 of BNS 2023, and also the search sheet of Hazu PS case number 154 of 2026 may be quashed. The submission of Mr. Chaudhary, learned counsel for the petitioner, needs further consideration, and this is this. This is not a joint petition.
No, that's it.
So notice will go then.
Yes, I made a party here.
Let notice be issued to the respondent, returnable in 4 weeks. Step be taken upon respondent number 2 by speed post and also by usual process within a today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Porthakur entered appearance and received notice. Recess will call for the scanned copy of the record from the Court of Learned JMFC Hazu. List the matter on for a fixed agenda. Interim pair of the petitioner will be considered on next step.
Thank you.
May I please, Lordship? Lordship, the petition under section 528 of BNSS for quashing of Miss Valence case number 25 to 26 pending before the learned SSM, not looking for. Lordship,
What is the ground?
Lordship, page number. So in among proceedings on a plane of the meaningful reading does not disclose any specific dated particulated act and domestic violence within the meaning of section 3 of the DV Act 2005 committed by the petitioner against the respondent at any point of proximity to the institution of this case. Squarely falls within the categorical enumerated the Honorable Supreme Court in State versus Haryana cases. In this cases already inherent by jurisdiction of this Honorable Court. And secondly, my lord,
At what
it's
is
a counter blast of MAD actually 104 2025.
at what is this the proceeding is pending?
Pardon, my lord.
At what is this the proceeding is pending?
For appearance.
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 petition enclosed in page number 16. Parties have not shared household since November 2021. Categorically stated in before in page 16. All the incident happened in 2014, 2016, this one also.
What are the pairs in the petition?
DB petition, madam.
Yes.
To restrain the opposite party from the community of further effects of domestic violence under 18, section 18, to direct the opposite party to pay rupees monthly maintenance for 50,000, to grant temporary custody of the minor children so applicant under section 21, and to award damages of the injuries and mental torture suffered under section 22, to pay rupees 2 lakhs for case number MED 104 2025 also cost for this case of rupees 1,50,000, and to any other relief or other reliefs court may deem fit and proper. No domestic violence has happened.
So
madam.
is she not entitled to this maintenance?
So
Under
there is a
section
pending
20?
matrimonial D case is still pending before the Honorable Nagaon District Court. If there isn't any matrimonial, there is an court, Honorable Court is allow the maintenance, and we were ready to pay the maintenance amounts. But this domestic violence case is not actually my lord here.
Have you gone through the decision of Supreme Court in Rajneesh versus Neha?
Yeah, I'm understanding.
You have seen?
Yes.
Is there any bar
No bar.
then?
But this one, Lordship, it is a completely false case, counterblast of this MED 104 only.
Okay, let notice go.
Already we filed in MED.
Heard Miss Mehdi, learned counsel for the petition. In this petition under section 528 of the BNSS 2020, the petitioner has tried for quashing the missed within bracket domestic violence case number 25 of 2026 pending before the Court of Learned SDJMS Port Lakhimpur. The learned counsel for the petitioner submits that the petitioner is the husband of the respondent who has initiated the proceeding under Domestic Violence Act being Miss DV case number 25 of 2026, which is pending before the Court of Learned SDJMS North Lakhimpur. Ms. Medhi further submits that the petition filed under section 12 of the Domestic Violence Act by the respondent herein does not disclose any specific date or particulars act of domestic violence within the meaning of section 3 of the Domestic Violence Act 2005 and in the end the case falls within the categories enumerated in the decision of Honorable Supreme Court in the State of Haryana versus Bhajanlal 1992, supply within bracket 1 SCC page number 335. 335 and also Saurabh Kumar Tripathi versus Vidhi Rawal reported in 2025 INSC 734. And she further submits that this domestic violence petition under 12 of the Act filed by the respondent herein before the learned SDGM is the counter plus of the title suit number
104, Meddi 104 2025.
Matri 105. You have mentioned it
104 of
in this
2025.
petition.
Where the petitioner, ma'am?
Where you have mentioned in which paragraph?
Page number 9. C,
Matri,
number
you can
C.
look at D case number 104 of 2025. And under such circumstances, he has contended to allow this person. The submission of learned counsel for the petitioner needs further consideration. At this stage, a notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Justice shall call for the scanned copy of the record from the learned trial court. List the matter after 4 weeks.
Instead of further proceedings, my lord.
Interim
The
pair of the
disposal of the
petition-
petition.
Interim pair of the petitioner will be considered on appearance of the respondent hearing and on receipt of the record from the learned trial court.
Flash.
Number 49.
Highly obliged.
You have filed the
Yes.
affidavit.
We have filed the affidavit, annexure 2 is the judgment of the trial court.
Annexure 2.
Annexure 2. Page 40 maybe. Produced. Page 40, Lord.
Heard Mr. Borman, learned counsel for the petitioner. In this petition under section 438, read with section 442 of the BNSS 2023, read with section 528 of the BNS 2023. The petitioner has challenged the judgment and order dated 5/6/2026 passed by the learned session judge Dhemaji in criminal appeal number 14 of 2024, whereby the learned session judge Dhemaji put in bracket appellate court has affirmed the judgment and order dated 31st of May 2024 passed by the learned additional chief judicial magistrate Dhemaji in NI case number 06 of 2026, convicting the petitioner under section 138 of the NI Act and sentence him to suffer sinful imprisonment for 4 months and also to pay a fine of rupees 16 lakhs with default stipulation. Peruse the memo of appeal, peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated 25/6/2026 passed by the learned session judge in criminal appeal number 14 of 2024 and also the judgment and order dated 31st of May 2024 passed by the learned additional chief judicial magistrate Dhemaji in NI case number 6 of 2020. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Upon respondent number 2 within a We are the warning from today. However, no formal notice is required to be issued to the respondent number one. Since Mr. Borthakur entered appearance and received notice, however, extra requisite copy of the petition may furnish to him during the course of the day. Recess will call for the records from the learned courts below and list the matter after 4 weeks. And pending disposal of this revision petition and also considering the submission of learned counsel for the petitioner. The sentence so handed down upon the petitioner hearing is then suspended till disposal of this petition. In terms of the order passed in this revision petition, the IA filed by the petitioner for staying operation of the in judgment and order stands disposed of. It's after 4 weeks.
Applies me.
May it please your lordship. This is a criminal petition, lordship, pray for quashing of the NI Act proceeding, lordship. In this case also, lordship, my learned friend want to file his wakalatnama, lordship, for respondent number 2.
We have filed, Lordship.
You have filed.
Lordship, we have not received the copy. So,
Before issuing notice, they have filed wakalatnama, lordship. So a copy
There is
was
no bar as such.
no, lordship. So lordship, if your lordship not issued notice today, then this matter, my humble request to take up tomorrow, as because 14 is the next date before the learned trial court
For
for lordship appearance of the party. He is on bail, but the proceeding is going on, lordship.
Lordship, I have received instruction that if the opposite party take adjournment on the next day of our appearance, we will not oppose it. And we will agree with that. So
But
that
Lordship, it
will
is-
be a bar on their part in the trial court. Okay with that.
Lordship may take up tomorrow, lordship, as a motion matter. In the meantime, I will serve them copy, lordship. That will be better. If I satisfy your lordship, then your lordship may grant stay of the trial court proceeding, lordship. In
the
one of-
record is not available.
No, lordship, notice not yet issued in this matter. This is a motion matter, lordship. And
No,
in similar.
Can we
matter-
consider the same without
Lordship, in a similar matter, coordinate bench already issued notice and granted stay, lordship.
Okay, you go to that bench then.
Lordship, no, lordship may take up this
No.
matter tomorrow, lordship.
No such urgency.
14 is the next date fixed before the learned.
Then
trial.
what is the ground for causing the
Lordship, they have provided some money to the company and to the hospital. But thereafter, during the execution of the agreement and all this, lordship, there was an understanding between both the parties that we will exchange some check in between both the parties. Accordingly, we have also issued some check in their favor, and they have also issued some check in favor of these 3 doctors, lordship. And thereafter, lordship, they have executed an agreement saying that we personally agreed to pay the amount which was given to the company. So we have issued the check, and thereafter the NI Act proceeding was issued, lordship.
Lot of contested facts in this petition, Lordship. And
Complaint petition, your lordship will find page 85.
voluminous petition, Lordship. So 1 day time, that is why we were thinking that 1 day time will not be enough. And as far as the trial court is concerned, we have already received instructions that we would not have any adverse comment if the next day they were to take adjournment on the day of appeal.
third Miss R. Chaudhary, learned senior counsel assisted by Miss So-and-so, learned counsel for the petitioner. And Mr. Mishra,
Hey, Mishra, on behalf of Mr. S. Nawaz.
S.
Nawaz.
Learned counsel for the respondent. In this petition under section 528 of the BNSS 2023, the petitioner has bribed for causing the NI case number 248 of 2025. Pending before the Court of Learned Judicial Magistrate First Class, Dibrugarh. Where is the petition and the documents? Let notice be issued to the respondent. Returnable after 2 weeks. However, no formal notice is required to be issued since the parties are represented by their engaged counsel, but extra requisite copy of this petition will be furnished to them during the course of the day. Rest shall call for the record from the learned, scan copy of the record from the learned trial court. List the matter after 2 weeks on fixed date.
Lordship,
28.
Lordship, the earlier petition, yesterday's petition was fixed on 25/8. So on the same date, your Lordship may fix
Okay, 25.
25/8. Lordship, if interim prayer will be considered on the returnable date, Lordship.
Okay. Interim period of the petitioner will be considered on returnable date after receipt of the record from the learned trial court.
And Lordship, my learned friend has already assured that they will not object, Lordship, that observation may be recorded, Lordship.
Sorry,
They have stated before this court, Lordship.
sorry, no such observation will be made in the order.
Oblige.
May I please, your Lordship? Lordship, this is for quashing of the proceeding, and today is the date for consideration of my interim prayer. Lordship, the FIR, on the strength of which the entire proceeding started, is start from page 23. And the last line of the FIR, the informant said that he has now refused to marry me after damaging my chastity. So here the informant, she is a lady having a child. Initially,
Whether, at what is this, the proceeding is pending?
Lordship, now it is the appearance before the session court, because the
Session court.
committal proceeding has already been over.
And under which provision charge sheet was submitted?
Charge sheet submitted under the provisions of
Whether this charge under section 376 can be quashed
Lordship,
in view of the decision of Supreme Court in Gyan Singh case?
Lordship, that has not been quashed now.
No. Can it be quashed?
Yes, Lordship. Because the Gyan Singh says that the heinous crime should not be quashed. And subsequently there are judgments where said, and here this is not under 376, because there is no offense under 376, because the parties were consensual. And now once the parties are consensual, then comes the intention. Whether the party was having the intention to marry her or not. That would be
Whether the evidence is available before this court to arrive at a conclusion that they are consensual.
Yes, Lordship. The evidence is there. Consensual, first of all, the FIR says that these are consensual initial stage.
Another
and
thing.
promise of marriage.
Another aspect of the matter is, can this court appreciate the evidence while dealing with a petition under section 528?
No, Lordship, your Lordship cannot appreciate the evidences
Then-
under 520, then here, Lordship, but here is a case where there is miscarriage of justice. Once there is miscarriage of justice, it is apparent from the FIR and the other documents available on record that without appreciating taking the evidences, that there was intention to this was consensual, and the accused was having an intention.
Those can be intention.
Lordship,
and-
the FIR says that last line, she has lost the FIR not because of the relationship, because the accused has refused to marry her. That is why the FIR was lost. And FIR was, last line of the FIR, it is at page 24. This is a case where they must be abused of the.
Mr. Tamule, you see how this power, extraordinary power under section 528 is to be exercised. That has been laid down in the case of Niharika infrastructure case.
Lordship, then subsequently there are certain judgment which says
Yes.
that court can go into deeper into I will produce that judgment if time is given, because today I have not prepared on that line. So there is a judgment which says probably by Justice Padriwala, wherein it has been stated that court can look into the evidences.
No, you see, the.
That has been enlarged.
Niharika decision is 3 judgments.
Lordship, I'll produce those judgments where these were also taken into consideration.
Mm.
And
And,
thereafter, Lordship,
and Mr. Tamuli, you see, trial court has not yet framed the charge against you.
yes, Lordship.
So, there is option for you to file an application for discharging you.
Lordship, that option is open to me.
Yes.
But here is a case because there was abuse of the process of law from the day one. I was put in jail without.
When your remedy is available before the trial court,
Lordship, even
can you invoke the power, invoke the jurisdiction of this court under 528?
yes, Lordship, because
No,
despite of availability of that remedy, I can come because here I am before your Lordship for quashing of the entire proceeding starting from the FIR. So that I can do even after the filing of the charge sheet also.
Parameters have been laid down in the case of Niharika infrastructure.
Lordship may take it up at 2 o'clock. I will satisfy your Lordship all on this particular point because I have those judgments with you.
So the notice was issued?
No, notice was not issued to the informant on the last date. Only TCR was called for because today is the date fixed for consideration of my interim payer. That is why the TCR was called for.
That notice go at this is hard, Mr. Tamuli, learned counsel.
Victim's 183 statement is also not available in record.
Lordship, I got the copy.
Record is it, but in the record, the statement is not there in there.
I got the copy, but the second page was missing because copy was supplied to me. At that time, second page was missing. When I asked for that, it was in seal cover. So they have said that it will be provided on the next day when the seal will be opened. So I have produced only 2 pages of the 183 statement of the victim.
Office note dated 6/8/2026 indicates that scanned copy of the record of session case number 182 of 2025 has been received. However, Mr. Borthakur, learned additional PP, has pointed it out that the statement of the victim girl recorded under section 183.
Yes, but 183 BNS
of the BNSS 2023, BNS 2023 is not available on the record.
164 statement. The first case is of 2020.
164 statement.
164 statement of the victim girl is not available on the record. Accordingly, it is provided that registrar shall call for the scanned copy of the statement of the victim girl recorded under section 164 CRPC. It also appears that notice has not yet been issued to the respondent number 2, though the record of the learned trial court was called for by order dated 15/7/2026. Accordingly, it is provided that notice be issued to the respondent number 2, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1. Since Mr. Borthakur entered appearance in this notice, our extra requested copy of the petition be furnished to them during the course of the day. This is a matter after 4 weeks. Interim pair of the petitioner will be considered on next date.
Lordship, may I pray for a date before 30th of August?
Correct.
30th of August. No,
Not
any date
possible
before
30th.
30th of August because it is fixed on 30th of August before the lower court. Any date before that.
It is 30 August.
Huh?
First is Sunday.
তাৰ আগত এটা
27th August.
much of it.
No, whether notice will be served in the meantime.
Yes, Lordship, because through speed post today I will take the step. Much of it.
Item 41 for orders. Arthur Miller.
Malata, in this case, they have filed the affidavit in opposition, and I have filed the reply also. But I have checked up the record, my lord, the reply has not come on record, my lord. That has been filed on Monday.
When did you file the reply?
Monday. Otherwise, well, let the matter be next week, my lord, along with my reply.
Third, Mr. Islam, learned counsel for the petitioner, none appears for the respondent on call, for the contempt or on call. Mr. Islam submits that he has filed one affidavit in reply on next Monday, but the same has not yet been tagged to the record. The SSL lists the matter on
Much of
lists the matter on 7th of September. A letter on Mr. Khatunier, learned counsel for the contender, appeared. 7th of September. SSL take the affidavit filed by the petitioner along with this record.
much of.
Item 42. Pardon me.
Which, yeah, my lord, director has passed the partly complied order, my lord.
Partly
Yes, his part is compliant, my lord.
Now what remains to be complied with?
Government has to comply. my lord. Matter was sent to the government, my lord.
The decision regarding provincialization in respect of the petitioner has already been taken by the committee, and accordingly a proposal has been submitted by the director to the government for issuance of the approval.
You are appearing for the government also,
Here, from the director is the party,
only.
only director.
No, my lord, government is party also. my lord. Okay, no, government also party, my lord. Oh, okay.
Only director.
Only director is the party.
Lord, director is the party as well as my lord. Government has already made party, my lord, government, my lord.
When?
My lord. My lord. I may be
Okay,
allowed-
government is party. Subsequently, it
Yes,
will
my
be-
lord.
So not you will keep it pending for some time.
Who will appear? Who will represent this?
I'll take instruction.
Okay. Heard Mr. Islam, learned counsel for the petitioner, Mr. Kosik, learned counsel for the contender number 1. Producing a letter dated 6th of June 2026, issued by the director
To the petitioner.
to the petitioner, Mr. Kosik submits that the director has complied with her part of the direction issued in WPC number 43/2026 of 2020. That is, Mr. Islam has pointed it out that the secretary to the government of Assam Department of School Education is also a party in this contempt proceeding. That is, Mr. Kosik submits that he may be granted some time to obtain instruction as to whether he can appear on behalf of respondent number 2. Respondent contender number 2. They are allowed to list the matter on
Deep oblige.
the letter produced before the court today shall be marked as annexer F and the capital letter.
And can it be 9th? I have some difficulty.
No, next date is only for obtaining instruction whether you can appear or not.
7th, I have some difficulty on 9th.
No, we can fix it in the next week then.
Yes, my lord.
No problem. No problem.
20.
Great.
Oblige.
My lord, the matter went for mediation, my lord. Mediation. The report has come, might be. Mediation failed, my lord.
Mediation. Mediation failed.
Yes, my lord. The matter may be fixed for admission, my lord.
Heard Mr. Bakshi, learned counsel for the petitioner, Mr. Devi for the respondent. It is submitted at the bar that though this matter was referred to the mediation, the same failed to yield any result, and as such, the matter may be listed in the admission column. Pair allowed receives a list the matter for admission on
Deeply obliged.
Item 44.
none appears for the applicant on call. However, Mr. Bortakur, learned additional PP present, lists the matter after a week. In the event of subsequent non-representation of the applicant, appropriate orders will follow.
45.
You are for? Respondent number?
Check.
None appears for the petitioner in call. However, Mr. Learned counsel appearing on behalf of? Pardon? AC Sharma. AC Sharma is the petitioner here. AC Sharma appeared for the petitioner. Petitioner. Mr. So-and-so learned counsel. Appearing for Mr. AC Sharma, learned conducting counsel for the petitioner, prays for adjournment of the matter for the day. Pair allowed. The matter stands adjourned for the day.
46.
May please, Lordship. But there is 36 days delay in filing the appeal, my lord. Notice may go, my lord, private respondent is there, my lord.
Heard Mr. Bhuya, learned counsel for the applicant. Mr. Borthakur, learned additional PP for the respondent number 1. This application under Section 5 of the Limitation Act 1963 is preferred by the applicant for continuation of delay of 36 days
36 days, my lord.
in preferring criminal revision petition.
Appeal, my lord.
Appeal.
My lord, my lord. I'm sorry, my lord.
Against the judgment and order dated 22nd of April 2026 passed by the learned session as Dhemaji in session case number 9 of 2016. Let notice be issued to the respondent number 2 returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Mr. Bortakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. List the matter after 4 weeks.
Oblige, my lord.
None appears for the applicant on call. List the matter after a week. In the event of subsequent non-representation, appropriate orders will follow.
47. My lord, in this case, that mistake is there, my lord. Designation mistake, my lord. I may be allowed to rectify the same.
Pardon?
my lord, I may be allowed to rectify the same, my lord. Some pagination mistake is there. my lord. So, my lord, on 19, my lord,
On the pair being made by Mr.
Harish Chauhan,
Learned Counsel for the applicant, raises and lays the matter on
19, my lord, 19.
19th.
Obliged.
For various item 27.
May I please, your lordship? Lordship, FIR is at page 9. It is an NDPS case and already been charge sheet has been submitted and 2 of the witnesses have been examined. The charge sheet was submitted on,
This is NDPS case,
yes, lordship,
commercial quantity.
commercial quantity. The commercial quantity starts from 250 grams and here 252 grams was recovered.
Heroin.
Not lordship, tramadol, Sempex plus
Report there, but presence of
Presence of
tramadol is there.
tramadol.
Tramadol 250 grams is the commercial
Commercial
quantity.
quantity.
Lordship, mainly on the length of detention. Lordship, today is 250 days. He was arrested on 4/12/2000. 4/12
But
2025.
if the quantum of contraband substance is commercial quantity, then you have to satisfy the section 37 of the NDPS Act.
Lordship,
How do
Point
you
of this-
satisfy?
section 37, the bar rider in section delay in the trial because it hits the fundamental right. That is why the considering the length of detention can be granted, lordship.
length of detention cannot be a ground by 30. Now, on 14/7, 2 witnesses submitted on additional affidavit.
I have given that witnesses of the informant and 1 seizure witness.
So, when he was arrested?
He was arrested on 4/12/2025.
4/12/2025.
Today is 250 days.
1 year might have not been completed. Only.
When the charge was framed?
Lordship, charge was framed on
Charge frame on 11/3/26.
11/3/2026.
Yes, sir.
So till now, 2 witnesses have been examined.
Yes, lordship.
So how the trial is delayed?
That is, I have said the length of detention.
Length of detention.
After 47, my lord. My lord, next date, my lord.
Today is the next day.
Okay, we will pass the order. Where is the scan copy?
Much.
28.
May it please, your lordship? Your accused was arrested under section 4 of POSCO Act, your lordship.
Here, my lord, is noticed.
Notice not served.
I'm trying to get that my lord report regarding notice that.
Record is received.
Record received.
Heard Mr. Rava, learned counsel for the petitioner. Mr. Borthakur, learned additional PP for the state respondent. Mr. Borthakur submits that he has not received the service report in respect of respondent number 2.
15 missing.
Then he pressed for granting him some time, parallel, list the matter on Tuesday.
Yes, my lord.
And on that day, Mr. Portago shall produce the service report, having obtained the same from the officer in charge jurisdictional PS.
President.
Yes, my lord, regular bail application, lordship. 83 days, my lord, before behind the bar, my lord. FIR, my lord, page 10, my lord. Charge sheeted matter, my lord, TCR was called for and that has been received, my lord.
Charge sheeted under section
It should be postponed another 75 to
8.
section 8 of the postcode 75.
What is the punishment under section 8?
3 years, my lord.
3 years.
3 to 5
3
years.
years.
And 75?
3 years.
There is 3 years.
Charge sheet submitted.
That is happening.
End of the
Any witnesses have been examined?
Not yet, my lord.
no, my not yet examined.
Not
End of the victim is 13 years.
Only thing, my lord, he kisses the minor girl of the informant.
The next date is fixed for consideration of charge on 14/8/26.
83 days, my lord.
83 days already, but unless the statement of the victim is victim and informants are recorded.
Let it come after the next date, my lord.
Next date is for consideration of charge on 14/8/26.
Okay, in the first week of September then.
Yes.
Okay. As agreed by learned advocates of both the parties, it is provided that the system lays the matter on. Second. It's up.
On 9 September.
9th of September.
Aulas.
30.
In the meantime, registrar shall call for the up-to-date scanned copy of the record from the learned trial court.
30.
Lordship, your trial has already commenced, Lordship. So looking at the Lordship allegations, I have very limited scope because the under 65(2) of the BNS and Lordship section 4(2) of the POCSO, Lordship. So Lordship, in this case, 4 witnesses has been examined till date, and 15 is the total number of witnesses. So the victim has been examined, the informant has been examined, victim father has been examined. So there is no scope of threatening them and all. So considering the length of detention.
How long you were behind the bar?
Lordship, from since 27/1/26.
Altogether, 15 witnesses have
15
been
witnesses.
cited.
Yes.
Out of 15, 3
4
have
has-
been examined.
3 has been examined. 3, no?
3 years.
So it will take more time to complete all the prosecution witness. So considering the length of detention, that is the only prayer, Lordship.
So charge pending on 22/4/26. And the section Lordship 65 to DNF and 4 for subsequent two.
Are the victim and the accuser neighbor?
Lordship. Yeah.
Neighbor. So, Mr. Goswami,
Lordship.
since the material witnesses have been examined,
Yes, Lordship.
can we consider his petition on the length of detention?
Lordship, allegation says 2 years, but she was apparently she was minor at the time of the incident. Lordship.
No, that's all right, but they have been examined.
Not examined. Lordship.
So the question of intimidation to the witnesses does not arise. These 3 witnesses at first. Yes.
On 8 September.
8 September, registrar will call for the up-to-date scanned
Yes.
copy of the record from the learned trial court.
31.
Mic is closed. Yes. Teacher was called for lawsuit. On last occasion, lawsuit police has submitted, that charge sheet has been submitted before the trial. court.
B Sharma.
But her name is not shown in the court record.
She was here. Okay. Okay, after some time.
Lawsuit.
May I please, the Lordship, 483 application is charge-sheeted case, POCSO case, Lordship. The two witnesses already been examined, the informant and the victim. Scan copy of the trial code was called for, and we have taken steps against the victim on 14/7/26. Whether the scan copy I sent. Scan copy is not there. The victim and the informant, they have been examined. He was arrested on 2/2/26.
Mr. Goswami, whether notice was served upon the victim? No, upon the informant.
So PP, we have taken steps.
TCR has also not been received.
Lordship,
Or
fixed it
Mr.
as
D.
short.
Talukdar, learned senior counsel assisted by Mr. Learned
We-
counsel for the accused and Mr. Goswami for the respondent. Office note dated 24/7/2026 indicates that trial court record has not yet been received. RESSL, accordingly, it is provided that RESSL issue urgent reminder to the learned trial court for transmitting the scanned copy of the record. Mr. Goswami also submits that he has not received any instruction in respect of service of notice upon respondent number 2. And he prays for granting him some time to obtain instruction, pair allowed, list the matter on
26 hours.
sorted
Before November.
24th August. On that day, Mr. Goswami shall produce before this court the service report upon respondent number 2, having obtained the same from the officer in charge jurisdictional PS.
33.
Wait, this is your lordship.
Yes.
This is a regular bail application, lordship. This case, this petitioner in jail custody for 110 days, lordship. FIR, lordship, will find on page 15, lordship. Initially, case was registered under 137(2), lordship, that is a kidnapping from lawful guardian, lordship. The age of the victim is given here in the FIR, lordship, 16 years, 8 months, lordship. The Xerox copy, lordship, the certified copy of the FIR that is on page 17, lordship. Vernacular portion, lordship. Age is reflected 16 years, 8 months. And this present petitioner is a 20 years old person, lordship. His forwarding report reflected on page 19, lordship. He's in detention from 24/4/2026 to the 110 days, lordship. After that, lordship, he has moved in bail
Search sheet
petition.
is submitted.
Yes, lordship, charge is submitted. lordship.
Search frame.
A charge frame, lordship, 2 witnesses has been examined, lordship. Informant and the victim, lordship.
First friend on 9/6/26.
May I submit, lordship? On page 21, lordship, the bail petition he has moved. That order reflect on page 21, lordship. There, lordship, the victim, third paragraph, lordship. Page 21, lordship. On receipt of the notice, informant has appeared before the court and by petitioner number such as such through the learned special PP raised is no objection to the bail period of the accused. Now, lordship, thereafter, in the meantime, lordship, 183 statement has been recorded, lordship, that is in the record, lordship.
No,
There-
the informant may not have the objection in granting bail.
Because
But
she-
does it mean that the court will consider the same and enlarge him on bail?
No, Lordship, things is that the victim and the petitioner having love relation, Lordship. That is reflected, Lordship, since the age is, Lordship, fall under, Lordship, below 18 years, Lordship, that is the only problem for him.
Yes, Mr. Bisa Siva for the respondent number 2. So you have no objection in enlarging him on bail.
Given a very wonderful, long evidence that he has, it was she who have taken gun report. And moreover, my lord, she has said that I am major and he has not kidnapped me. The evidence is very happy.
So you have no objection.
She has given different evidence. Change her statement earlier. Is that I have not stated before the IO or before the magistrate on this thing.
She has been declared hostile.
Yes, she has been declared hostile, Lordship. Page 33 kindly follow, Lordship. Kindly peruse, Lordship, page 33, paragraph number 10, Lordship, cross-examination part.
That magistrate that there was physical me and the cell phone on 84 and stopped.
Yeah, please, Lordship, the matters pertaining to POCSO. On last occasion, amicus curiae was appointed by Lordship. Lordship, the petitioner is in judicial custody for last 147 days as of today. And
147 days.
Lordship. And
147 days.
Lordship. And as per
For the accused and Mr. Goswami for the respondent. Learned additional PP for the state respondent. Mr. Goswami submits that he has not received the case diary. And it also appears that notice upon respondent number 2 is yet to be served. You have taken a step.
Yes, taken step.
How?
Registered. As for the order of the court.
No, there is a office note that registry has not received the notice.
Yes, the instruction of clerk. Yes, I will check.
However, it appears from the office note dated 10/8/2026 that step for issuance of notice to the respondent number 2 has not been received by the registry. Mr. Hazoika submits that he will examine the matter.
Yes.
List the matter after when? After 1 week.
Take me the picture.
After 1 week.
26.
And
difficult.
in the event of step not being taken till that, Mr. Hazarika is directed to take steps within 2 working days from today
20.
through the office of the public prosecutor, Gauhati High Court.
Item 36.
My lord, this is a charge sheeted case, my lord. The petitioner was carrying some cough syrup, my lord. Although, my lord, he is the petitioner is a, my lord, your lordship will find page 19 is the charge sheet. And he is a, my lord, B
This is
farmer.
charge sheeted case.
Charge sheet case. He is a B farmer, my lord. As arrested on, my lord.
Charge has been framed. Not framed.
24 and 26.
Under section
26. 22C.
22C, my lord. My lord, he is a working in a, my lord, Messrs. Hindustan Pharma. And he is a technician, my lord. He is a B Pharma, qualified. He is carrying some bottles to supply to some customers, my lord. And out of doubt that he has been selling this, he is not directly involved, my lord. So, my lord, he is having a degree.
No,
degree
the consignment was found in his possession.
in possession, my lord. He is carrying, my lord.
Then
He is he is going to supply to the customers, my lord.
Yes,
But whether any valid bill or valid invoice are received or not, that is not there, my lord. But
no, it is your duty to produce the relevant documents that you have carried the same under any receipt or
the license, my lord. This is
any
the license, my lord. He has the company. This company has the license, my lord.
license of?
License of, my lord, dealings this cough syrups, my lord. They are the manufacturing. He is the employee of that, my lord. His name is Dipankar Sarkar. Employee number 2, testing chemist, my lord. Is. Although he has not any valid other invoice or vouchers, my lord. But my lord, already more than 100 days.
No, this is in respect of
His name is there, my lord. He's a so my lord, relation may consider he will face the trial if my lord.
you
He's
have
the
been
employee of
granted. No,
employee of
Mr.
Hindustan Pharma Tech, my lord.
You have been granted license to manufacture drugs specified in the Schedule C, C1 and X.
Yes, my lord.
So in which category this these articles, these cough syrups falls?
That is, I'm not confirmed. That is to be
You cannot
See,
confirm.
maybe.
No, you have to show that on the strength of this license, you have carried those contraband substances in your vehicle.
And it is confirmed that he is the employee of that company, my lord.
Maybe.
Mr. Hindustan Pharma, my lord. So he was entrusted to deliver this to the customers, my lord.
Can it be said that
Personally,
the
he is
offense is
selling
not
to any
made out
other, he
against
is
you?
not selling to any other private persons, my lord. Those who having the drugs license, they are the supplier, my lord. So from trial that will reveal, my lord, I will face the trial. So more than 110 days.
No, that's all right. But when the quantity is of commercial quantity, then you were to satisfy section 36, oh, sorry, 37.
Yes, my lord. But commercial.
How do you satisfy the requirement?
Obtain it 26 from last.
10-8.
Obtain it 26. So any evidence can be examined on that.
So, my lord, there is no question of already, my lord, investigation, no any private witnesses is there, my lord. Only documentary proof.
That's all right. We
No
are
question of
concerned with,
hampering or tampering any witnesses, my lord.
this is not a normal
Section
paid
27 is, I have to prove that only whether it is for consumption or not. Section 27, whether it is private consumption or not, or any license holder.
We are not concerned with that. We are concerned with section 37. How do you satisfy?
Oh, that is, my lord, whether it is cognizable or not cognizable. That is, my lord, during trial, I will prove that whether I have the valid license or not. If I have the valid license, then that is not attractive. 37 is that, my lord, whether, and 27 will come up that, my lord, whether it is private consumption or drugs or not, or it is.
No, the FSL report is available.
No, only question is that whether only for selling to the private persons or to the license holder. 27 is that, my lord, whether it is consumption in aquatic dubs
You
or
say,
packaging
Mr. Nath,
substances.
this section 37 1 B Roman 2. You have to satisfy these two conditions.
Yes, my lord. That is, my lord. Uh, he is not a regular offender, because only it is that what the public prosecutor possesses the application of the court, satisfied that there are reasonable grounds for believing that he is not guilty of such offense, or that he is not likely to commit any offense while on bail. So, my lord, since he has some diploma, he is an educated boy, my lord. He is not regularly committing such offense, my lord. So, only point is that, my lord, whether that is for private consumption or to the public or to the license holder. Main thing is that is because in the pharmacy we can purchase these products.
Okay.
So they have the license.
Next slide.
57.
Lord Chief, kindly pass over the matter at the time being.
In this case, Moscow is there, but my trust on the police control went to after notice to the victim, but not the hospital. So, notice to not be served on that particular. So, we wait for 2 days time to serve the notice to the.
Okay. After 2 days.
After 2 days. So, on Tuesday.
Third Miss
Jan Khandogar.
Learned Counsel appearing on behalf of Mr. J. Ahmed.
J. Ahmed.
Learned Counsel for the applicant. Mr. Borthakur, Learned Additional PP for the state respondent. Mr. Borthakur submits that notice upon the respondent number could not be served. And as per his instruction, the respondent number 2 is in the hospital, and as such, the IO of the case press for granting 2 days time to effect service of notice upon respondent number 2. And Mr. Borthakur therefore contended to list the matter after 2 days. They are allowed to list the matter on
19 August.
19 August. On that day, Mr. Borthakur shall produce the service report before this court. Case ID received? Till then, case ID is retained.
Item 38.
This is a 452 application, Your Honor.
Case ID not received.
This is the third time, Your Honor. The interim protection may be given. Basically, as per the FIR, the allegation is basically accused number 1, that is the husband of the informant, Your Honor. The accused number 2 is no connection with this case, Your Honor. Basically, the dispute between husband and wife, Your Honor.
Oh, why the CD has not been received, Mr. Borthakur?
Moreover, after 2 months later, the informant lodged an affair, Your Honor. As per the affair, kindly have a look at the case number 15, Your Honor, affair, Your Honor. Sorry, 22, Your Honor.
Okay, let the city come, we'll say the offenses are serious. Mr. Your name, please?
Your interim protection may be given, Your Honor.
Your name, please?
Hi, Your Honor.
Learned Counsel for the applicant, Mr. Borthakur. Learned Additional PP for the state respondent. Mr. Borthakur submits that he has not received the case date. The Learned Counsel for the applicant, however, pointed it out that on 3 consecutive dates, the Learned Additional PP has failed to produce the case date before this court, and accordingly, he has applied for consideration of the interim pair of the applicant. However, Mr. Bortaku submits that a license may be given to him to furnish the case before this court. They are allowed to leave the matter on fixed sorted Friday.
Friday. 14 hours.
Oh, Friday also.
39.
Agree with Lordship, no?
Yeah.
My lord, according to the direction of the Honorable Court dated 24/7, it's a anticipatory bail, my lord, and I'm on interim.
You have appeared before
Yes,
the
my
IO.
lord, on 1/8 I've appeared. And recorded in the statement.
Bortaku CD received here.
Did he receive, my lord? Yes, he has received, my lord. Otherwise, there are materials the person who has had the, my lord, count of the, my lord, victim, my lord, thereafter, my lord, doing all this. Okay, so there are evidences regarding that, my lord. And computers of where he has done all the editing, my lord. His statement 183, my lord, statement is also available in the city.
Everything
Since
is.
he has been cooperating with the investigating agency, let us dispose of this matter. Heard Mr. Mitra, learned counsel for the applicant, Mr. Bortaku, learned additional PP for the state respondent. This application under section 482 of the BNS 2023 is preferred by applicant, namely Harshit Nahata, who has been apprehending arrest in connection with Silsor PS case number 306 of 2026 under section 316 within bracket 2, 318 within bracket 4, 319 within bracket 2, 335, 336 within bracket 3, 336 within bracket 4, 340 within bracket 2, 61 within bracket 2 of the BNS 2023 reduced section 66, 66C, 66D of the IT Act. Test to be noted here that above noted case has been registered on the basis of one FIR lodged by one. Who lodged the FIR?
My lord, my brother. Kumati Kumar Nahata. I'm sorry, my lord, Manish Nahata.
In which page it is mentioned?
My lord, in page 24.
All are related, my lord, victim, accused, there also.
Manish Nahata on 2nd of April 2026. The allegation against the present applicant is that after some manipulation, he has hacked the email ID of the informant and attempted to change his profile on the ICAI portal. And also attempted to hack the admit card so as to prevent him from appearing in the examination. Mr. Mitra, learned counsel for the applicant, submits that this court by order dated 24/7/2026 was pleased to grant interim relief. And pursuant to the said order, the applicant had appeared before the IO and he has been cooperating with the investigating agency. And on such count, he has applied for making the interim order dated 24/7/2026 absolute in the same terms and conditions. Producing the case before this court, Mr. Bortaku, learned additional PP, also confirmed that the applicant had appeared before the IO and his statement is recorded. However, Mr. Bortaku submits that the IO has collected sufficient incriminating materials against the present applicant and therefore he has opposed the petition. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents placed on record and also files the case diary with the assistance of Mr. Bortaku, learned additional PP. It appears that the IO has collected some incriminating materials against the applicant, but it also appears that the applicant was granted the privilege of interim PRS bail and pursuant to the said order dated 24/7/2026, he appeared before the IO and cooperating with the investigating agency. And in that view of the matter, further custodial interrogation of the applicant seems to be unwarranted here in this case, and accordingly, the interim order dated 24/7/2026 is hereby made absolute in the same terms and conditions.
Like, my lord.
May I please, Lordship?
Yes.
Lordship, this is bail application under section 482, Lordship. And the FIR is at page 13, Lordship. The allegation against the petitioner is there on 23/6/2026, Lordship. He went to the house of the informant and in the morning.
Heard Mr. Bardolo, learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. This application under section 528 of the BNSS 2023 is prepared by the petitioner, namely Hibzul Alam,
Lordship.
for causing the challenging the order dated 17/5/2024 passed by the learned special judge Pokso Kasar Silsor in special Pokso case number 3 of 2024, whereby a non-violable warrant of arrest was issued against the petitioner, and the subsequent orders dated 25/7/2024 and 5/12/2024 passed in the said case, whereby the petitioner was declared as proclaimed offender, and proclamation as well as attachment proceedings were directed to be initiated against the petitioner. As the petition and the documents placed on record, let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice, but extra requisite copy of the petition be furnished to him during the course of the day. Recessal call for the scanned copy of the record from the learned trial court. Record of special POCSO case number 3 of 2024 from the learned trial court. That is Special Judge POCSO Kasar Silsor. Fixing the matter on 9th of September. Interim pair of the petitioner will be considered on next date.
Lordship. May it please your lordship. Lordship, in this case, what had happened, lordship, and complaint was lost, and subsequently Hailakandi PS case number 18 of 25 was registered, lordship. The petitioner's name was not in the complaint, lordship. Thereafter, what had happened, lordship, the petitioner has approached the learned additional session judge by filing an anticipatory bail application, lordship, and which was subsequently allowed by the learned trial court, lordship, and that interim bail was granted, lordship. The interim bail granted was made absolute, lordship. But lordship, due to some threats, lordship, of his life and apprehension of abduction, lordship, he could not appear, lordship. In this regard, lordship, he has filed one complaint before the East Agartala police station, lordship. Kindly peruse page 30, lordship. Page 30 and extra D, lordship. Can I go through it, lordship?
No, not necessary. This petition is for
Lordship, this petition is for setting aside the order cancelling the bail of the petitioner, lordship. Lordship,
whether any specific provision is there in the BNSS regarding cancellation of bail. You are for cancellation of bail.
No, lordship. No, I am not for cancellation of bail, lordship. My bail was granted, lordship. Thereafter, lordship, the concerned IO has filed a petition for cancellation of my bail, lordship, which was allowed, lordship. Before the order was passed, I have approached several times to concerned police station regarding threat of my life and apprehension, Lordship, of abduction, Lordship.
Okay, at first you have been granted the privilege of PRS bail,
Lordship.
and it was interim or
Lordship.
interim or final, that order was.
Firstly, it was interim, Lordship.
Thereafter?
Then interim was made final, Lordship.
Final.
Absolute, Lordship.
And thereafter, the IO has prayed for cancellation of your
Cancellation of
bail,
Lordship.
and that was allowed.
That was allowed, Lordship. Against that order, Lordship, I have approached this honorable court. Before cancellation, Lordship, I have approached several times, Lordship. One, I have submitted a complaint before the East Agartala
You
police
approach
station.
home.
First, at page 13, Lordship, I have approached the East Agartala police station,
No,
Lordship.
no, where the case is registered.
Hailakandi, Lordship.
Then where is the question of approaching the police station at Agartala?
I am a resident under the jurisdiction of that particular police station, Lordship. I have also informed the officer in charge of Hailakandi, Lordship, which is at page 34, before the order was passed, Lordship.
Okay, let notice go. Let
Well, notice
record
may
go.
go, Lordship. Till then, no course of action. That must, Lordship. No course of action, Lordship.
Where is the question of no court of action will already he has granted bail after non-compliance of those conditions. There is no hope.
Let the record come, we will see. Heard, Mr. Bordolo, a learned counsel for the petitioner, Mr. Borthakur, learned additional PP for the state respondent. Order dated 25/6/2025 was by the learned additional session judge Hailakandi in criminal miscase number
67, Lordship, of
B,
25.
bracket B, number 67 of 2025 is challenged in this petition.
May I submit, Lordship? 66, Lordship. Criminal miss B, 66 of 25, Lordship. Page 35.
66 of 2025 is being challenged in this petition under section 520 of the 28 of the BNSS 2023. Mr. Bordolo, a learned counsel for the applicant, no, petitioner submits that the applicant herein was granted the privilege of PRS bail in criminal miscase number 67 of 2025 by the learned additional session judge Hailakandi,
Lordship.
wherein the learned additional session judge has imposed some condition, and the petitioner herein could not fulfill the said condition, on account of which the investigating officer has filed one application before the learned additional district judge, additional session judge Hailakandi, upon which criminal miscase number 66 of 2025 was registered. And after hearing the parties, the order dated 25/6/2026, by which the privilege of PRS bail was granted to the petitioner, was cancelled by impugn order dated 10/4/2026. No. By which the order dated 10/4/2025 in Miss B number 66 of 2026, whereby whereby the privilege of PRS bail was granted to the petitioner, who was cancelled by impugn order dated 25/6/2025 in criminal miscase number B number 67 of 2025. Where is the petition and the documents placed on the record? Let notice be issued to the respondent, returnable in 2 weeks. However, no formal notice is required to be issued since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Recessal call for the scanned copy of the record of criminal misc B case number 67 of 2025, and also Criminal Misc B case number 66 of 2025 from the Court of Learned Additional Sessions Judge Hailakandi on 28 August.
Lordship, no coercive action till then, because kindly peruse annexure E, Lordship, for a once, Lordship. No coercive action that much, Lordship, till then, Lordship. Because before my bail was cancelled, Lordship, I have submitted two representations before two police stations, Lordship, which were subsequently, Lordship, received by the concerned police station, Lordship. Thereafter, my bail was cancelled, Lordship.
No, you have filed those application at Agartala.
First one I have filed before the Agartala, and second one before the concerned police station, Lordship, which I have also annexed, Lordship. So till then, no
Let
coercive
the
action,
record
Lordship.
come, interim pair of the petitioner will be considered on next date. After receipt, on receipt of record from the trial court.
Obliged, Your Lordship.
Please, Lordship. I mean, custody for 102 days, Lordship. 102 days, 102 days. I'm on long-term detention, Lordship.
629, 626. But this was 65, one of the NFT, one for a POCSO.
Yes.
My please, Lordship. I'm in custody for 102 days, Lordship.
Hmm.
Sorry,
Here, surset is submitted
submitted, Lordship.
under section 4 of the POCSO Act.
Yes, Lordship. But
Uh,
if we pay
The statement of the victim under section 183 is available,
Fully implicated, Lordship.
fully implicated.
as per the statement, Lordship, may attract 8, Lordship.
That will be decided on the last time.
Exactly. Exactly, Lordship. Last date was on yesterday, Lordship. Well, yesterday was fixed for copy. The next date was probably, I have gone through the e-code, 24
When the next date is fixed.
24th of August.
Let
that
us
fixed for-
fix this matter after 24.
Yes, Lord.
Let us see
Yes, Lord.
under which section the charge is framed.
Yes, Lord.
Okay, heard Mr. Sauria, learned counsel for the petitioner, and Mr. Goswami for the respondent, state respondent, additional PP. Ms. B. Sharma, learned amicus for the respondent number 2. Place this matter on. Okay. 28 August.
Lordship.
28.
Deeply obliged, Lordship.
For further consideration, in the meantime, recess shall call for the up to that scanned copy of the record from
Deeply
the
obliged.
learned trial court.
For admission. Item number 19.
After some time, my lord, I have already called him, Mr. P. Dotto.
Oh,
Pankaj P. Dotto, my lord. Let him come for, today for instruction of the secondary education department. my
after
lord.
some time. Okay, all right.
I will wait, yeah.
Item 21.
None appears for the petitioner on call, lays the matter after a week. In the event of subsequent non-representation of the petitioner, appropriate order shall follow. Mr. Goswami, learned additional paper for the state respondent present.
May it please, Your Lordship. So the statutory appeal, my lord. I've been convicted under section 448 and 354, my lord, and sentenced to undergo 3 years imprisonment, my lord.
You are on bail now?
I am on bail, my lord. I was granted bail by the learned trial court. There's only one difficulty, my lord. I have given the additional affidavit in the IA.
What?
My lord, additional affidavit to bring on record one order. My lord, the statutory period for filing an appeal before this honorable court is 60 days. We have filed the appeal before that, my lord. But the learned trial court, before expiry of the 60 days, has cancelled my bail, my lord.
Now you are not on bail.
My lord, bail was granted on the last date, my lord, this bail order has been cancelled, my lord. I've given that on additional affidavit. So my prayer before your lordship is because it is a 3-year offence, my lord. Under 389(3), my lord, I'm entitled to bail. So instead of previous bail, my lord, I'm praying that I may be granted fresh bail, my lord.
Heard Mr. Nawaz, learned counsel for the petitioner. Now for the appellant and Mr. Goswami for the respondent number 1. This appeal under section 415 within bracket 2 of the BNSS 2023 is directed against the impugned judgment and order dated 9/6/2026 passed by the learned additional session judge number 4 FTC Nagaon in session within bracket T2 case number 150 within bracket N of 2019. This to be noted here that by impugned order, judgment and order dated so and so, the learned trial court has convicted the appellant herein under section 354, 448, 34 IPC and sentenced him to suffer rigorous imprisonment for simple imprisonment for 3 years and also to pay a fine of rupees 2,000 each with a default stipulation. And also sentence him to suffer imprisonment, simple imprisonment for 3 months under section 448 and also directed to run both the sentence concurrently. Peruse the memo of appeal and the grounds mentioned therein and also peruse the impugned judgment and order dated so and so. Admit, issue notice to the respondent returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Goswami entered appearance and received notice. But extra requisite copy of the memo of appeal be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. Recess shall call for the record from the learned court below. List the matter after 4 weeks. In ayat takedown, heard Mr. So. This interlocutory application is prepared by the applicant for allowing him to go on fresh bail. Learned counsel for the applicant submits that the applicant stood convicted by impugned judgment and order dated so and so by the learned appellate court. Additional session judge number 4 application Nagaon in T2 case number 150 within bracket N of 2019. Herein after the learned trial court and sentence to undergo learned counsel for the applicant submits that the applicant was allowed to remain on previous bail by the learned
Granted fresh bail.
appellate court.
Fresh bail, my lord, page
Trial
40.
court. Fresh bail.
Fresh bail, my lord, page 40.
Fresh bail. But subsequently that bail order was cancelled.
Yes, my lord.
Why?
My lord, the learned trial court fixed 30 days time for filing the order, my lord, but the statutory period is 60 days. That is, your lordship will find at page 46 of the additional affidavit.
Page number?
Page number 46, my lord, in the additional affidavit.
Granted bail under section 389(3) within bracket 3 within bracket Roman 1 of CRPC and suspended the same for a period of 30 days And since the applicant herein has failed to prefer the appeal within the period of 30 days, the bail order dated 11/6/2026 was cancelled. And under such circumstances, it is contended to allow the accused to go on, appellants to go on fresh bail. Having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, the appellants herein are allowed to, no, the applicants herein are allowed to go on fresh bail on their executing a bond of rupees 10,000 with one surety of like amount to the satisfaction. What was the earlier bail amount?
My lord, earlier bill amount is 20,000.
20,000 with one surety of like amount to the satisfaction of the learned trial court. Trial court. In terms of this, I sense closed.
I'm deeply obliged.
Lordship, I may be allowed to another 2 weeks time as per instruction of department to whether the provisional regarding the release of provisional pension.
Entitlement is there, my lord, as per earlier order of this honorable court, my lord.
No dispute that he is not entitled for OPS, Lordship, but one problem has been crop up, Lordship. The petitioner along with another 120 petitioners who were earlier under NPS, and in so far as the petitioner case is concerned, he has been released the NPS amount also 90%. So that portion also after regularization of all this amount, that the OPS amount will have to be calculated. For that, the department has seeking instruction from all the districts, the similarly situated person like petitioner, and what would be the amount of OPS.
No.
Lordship, I understand the query of, and that the petitioner has also court query also, but at least 2 weeks time will be granted.
No, Mr. Dotto, see, the other persons are not available before this court.
No,
Exactly, my lord.
but we will have to sort out the thing.
No, that is your problem. You can sort it out, but you cannot keep this matter pending for indefinite period before this court.
That is correct, Lordship.
Mm.
At least one opportunity granted to department to take up the call in the matter, Lordship.
No, my lord. In fact, my lord, in my case, my lord, I am praying for a provisional pension at least. Let them, my lord, everything will be done. By this time, they will provide release the provisional pension for the month September, my lord.
You have also availed the benefit of NPS. You have 90% have already been withdrawn by the petitioner.
No, that will be adjusted if a old pension is granted to,
Not only
OPS is granted to him.
yes, other persons are also in the same line.
You see, prima facie, whether he is entitled to OPS or not. When he was appointed, when his service was regularized, whether it is prior to 2005 or not.
Yes.
If it is before 2005, then there is no question of refusing the old pension scheme to him.
One judicial order also in his favor.
Then?
One director is also passed the OPS.
Then?
But in the meantime, he has availed the NPS and others
No, that cannot be. If he has availed it, that can be adjusted against the.
At least
By compulsion, they have, my lord, at the time of regular.
This time may be granted to ask Lordship. We will have to come back to one concrete instruction. Another problem, Lordship, though I am to say that all the employer has been borrowed by the election in census duty. We have also handicapped a little bit manpower also in these days. These are some practical difficulties, Lordship.
Maybe, Mr. Dotto, you see, the person has retired in the year
2023, my lord.
23. Except the NPS, he has not been receiving any of the benefit.
GPS paisa, GPS.
No, no, my lord, he has nothing received, my lord. So, that's why I am praying before your lordship for release of a provisional pension. Let them release the provisional pension, and by this time, after finalization of his pension, my lord, let them deducted the amount, my lord, whatever it may be.
For that, you will have to.
Heard Mr. Ayalam, learned counsel for the petitioner. Mr. PP Dotto, learned standing counsel for the education department. Being respondent number 1, 2, and 6. Ms. Sharma for respondent number?
Respondent number 3 for
Respondent number 3. And Ms. B. Deka for secondary education. B Decca is not there. She was earlier there. You are for the respondent number 5, 7, and 8. Elementary or secondary?
No, she is for elementary education.
Or you are for secondary?
Yes.
Okay.
The alia work under elementary education.
Elementary education department being 5, 7, and 8. Mr. Dotto submits that he may be granted some more time to obtain instruction in respect of granting provisional pension to the petitioner. Accordingly, taking note of the submission of learned counsel for both the parties, Mr. Dotto is granted 1 week time to obtain necessary instruction. And recessal lays the matter on on 19th of August.
Can it be 21 Lordship?
Okay, 21. 21. 21, my lord, it's holiday. I think.
No, it's Friday.
September 21.
21 September. 21st August.
21st or 25th.
Probably.
I think 23.
Please, Your Lordship, criminal revision petition for grant of interim custody of the petroleum products seized.
Interim custody of petroleum products. When it was seized?
Lordship, it was seized on 25/6.
25/6.
Or it was seized on
Yes,
25/6.
Mr. Goswami.
Report was called for, we have received a report of the I read the relevant paragraph. During the course of investigation, the family members of the accused produced certain parcel slips relating to seized petroleum products. The investigating officer seized the seized documents and duly verified the same during the investigation. Upon completion of the investigation, the investigative officer submitted the charge sheet by charge sheet number 40/26 to the 28/7/26. And the original case diary along with all connected records was forwarded to the honorable chief with the based in Kualpara. The seized petroleum products are highly inflammable and hazardous in nature. Keeping such a large quantity of petroleum products in the police station campus causes a serious risk of fire, explosion, and danger to human life as well as government property. Since the investigation has been completed and the charge sheet has been already been submitted before the honorable court, these petroleum products are no longer required for the purpose of investigation. So, and then we can get the record. The thing that the purpose of investigation it is not required now. So,
Okay, now who is the owner of the petroleum products? Seized petroleum products.
They have for the report they have produced some certain parcel slips.
I have already
Already members of the accused.
My lord, actually, the petitioners, they live in a joint family and they are farmers by nature. So,
No, you have enclosed the documents here
yes,
regarding purchase
yes, Lordship. Page number 19 to 29.
19 to 29.
Yes, Lordship. All the purchase slips are enclosed there. Yes.
Heard, Mr.
You can.
Learned counsel for the petitioner and Mr. Goswami, learned additional PT for the state respondent.
Lots of one more submission. I have also rented a commercial premises for the storage of these petroleum products with all the fire safety measures there. I have also submitted the rent agreement in Annexure 4, page 30.
You have the license to keep the petroleum products with you.
Lordship, it was actually used for all the household purposes and then the farming purposes.
Or
For farming, all those farming machinery, some require petroleum. And my lord, actually at that time, the petrol prices were increasing day by day. So they bought in a bulk and kept it to be used there.
but are you entitled to store the same without any license?
Required. Lordship, therefore, actually,
Even no, you see, if we release the articles in your custody, then again one case may be registered against you.
Lordship, now it is not in a place which is residential by nature. It is in a farmland which is big enough, and there it will.
No, that's all right, but
fire
there is a
safety
limit. You cannot store the inflammable substance, even if your farmhouse also.
Beyond the limit.
Beyond the limit. What is the
Lordship,
limit?
it will eventually be used. I have to check it out. What are the limit? It will be eventually used by them only. Lordship. It was for personal use.
In this petition under section 438, 442, and 528 of the BNSS 2023, and read section, read article 227 of the Constitution of India. The petitioner has challenged the order dated 19/6/2026, passed by the learned judicial magistrate first class Goalpara in petition number 558 of 2026, arising out of Dhupdhara PS case number 27 of 2026. Learned counsel for the applicant petitioner submits that in connection with Dhupdhara PS case number 27 of 2026, the investigating officer has seized huge quantity of petroleum products, being 25 plastic drums, each containing 40 liters, from the residential premises of the present petitioner.
Yes. He is the father of the main accused.
Of the present petitioner, who happens to be the father of accused Monirul Islam.
Yes.
Monirul Islam. And thereafter, investigation was carried out and charge sheet has been submitted before the learned trial court. And the being charge sheet number 40 of 2026, dated 28/7/2026. Thereafter, the petitioner has filed one application in petition number 558 of 2026 before the learned judicial magistrate first class Goalpara, but seeking custody of the seized petroleum products. But the learned court below, by impugn order dated so and so, has dismissed the petition. The learned counsel for the petitioner submits that the petitioner has purchased the same from Digholi service station situated at Digholi, Goalpara, Digholi Part 2, Goalpara. And the vouchers of such purchase is being enclosed with the petition as Annexure 3 series. Annexure 3 series from page number 19 to page number 29. Page number 29. And that the seized petroleum products will be used for farming purpose by the petitioner, and since investigation has already been completed, the petroleum products may not be required in the interest of an investigation, and therefore he has contended to allow this petition by setting aside the impugned order passed by the learned trial court. It is to be noted here that a report was called for from the investigating officer by the order dated 15/7/2026. And pursuant to said order, Mr. Goswami has produced the report of the IO today. And perusal of the same indicates that the investigation has been completed and charge sheet number 40 of 2026 dated 28/7/2026 has been filed before the learned Chief Judicial Magistrate Golpara. And the said report also indicates that being the seized petroleum products are highly inflammable and hazardous in nature. It is difficult for keeping the same in the premises of police station. And that the petroleum products are no longer required for the purpose of investigation. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the documents produced before the court in respect of ownership of the aforementioned seized petroleum products, and also considering the report submitted by the IO, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 1 lakh, the seized petroleum products shall be released in favor of the petitioner herein. And to facilitate in carrying out such an exercise, the impugned order dated so and so passed by the learned trial court is then set aside and passed. The report produced before the court shall be tagged to the record.
If the obligation.
Item 24.
Yes.
May I please your lordship? Your lordship, this matter is regarding to NI Act matter where the petitioner was convicted.
Convicted under section
38 of the NI Act.
and sentenced to
Sentence number, page number 37, Your Honor. Sentenced to undergo simple imprisonment for a period for 3 months under section 130 of NI Act and to pay compensation in sum of rupees 4 lakhs to the complainant. The compensation shall be recovered as a fine, and in default to as such compensation, the convicted shall undergo simple imprisonment for a period of 2 months.
So you are on bail now?
Yes.
Or please
P. Ghosh.
learned counsel for the petitioner. This petition under section 438, 442 of BNSS 2023.
My prayer is for stay in the execution. Okay.
In this petition under section 438, stroke 42 of the BNSS 2023, the petitioner has challenged the order dated 28/1/2026 passed by the learned additional session judge number 2, Kamrup M. Gauhati, in criminal appeal number 28 of 2025. 5. It is to be noted here that by the impugned order dated so and so, the learned appellate court has dismissed the appeal and affirmed the judgment and order dated 5/2/2025 passed by the learned subdivisional judicial magistrate number 1, Kamrup M. Gauhati in SEER case number 78 of 2020. It is also to be noted here that by the order dated judgment and order dated 5/2/2025, the learned trial court has convicted the petitioner herein under section 138 NI Act and sentenced him to suffer imprisonment for 3 months and also to pay a fine of rupees 4,000. No, sorry, 4 lakhs as compensation with a default stipulation. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated so and so passed by the learned appellate court and also the judgment and order dated so and so passed by the learned trial court. Issue notice to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Upon respondent number 2, however, no formal notice is required to be issued to the respondent number 1 since Mr. Goswami entered appearance and received notice. However, extra requisite copy of the petition may be furnished to him during the course of the day. Place the matter after 4 weeks. Is there any IA?
Yes, sir. You dispose.
No, for allowing you to remain on previous way.
Yes. Yeah. And the stay in the execution matter.
No, IA was for condonation of delay.
Yes.
Here, where is your pair?
You mean.
Hmm?
Okay. State that your lordship would be pleased to admit this petition, call for the records of the case from the courts below, issue notice to the respondent to show cause as to why the impugned judgment order dated 28/1/26 passed by the London Additional and District Session Judge number 2, Kamrup Metro in Gauhati in criminal appeal number 28 of 2025 as well as judgment order dated 5/2025 passed by the London Subdivisional Judicial Magistrate SDJM number 1, Kamrup Metro Gauhati in CR case number 78 of 2020 should be set aside after hearing the parties and would be pleased to set aside the impugned judgment as and orders passed by the learned courts below and allow the accused petitioner to remain on previous bail and further say the impugned judgment and orders and further after hearing the parties to please to direct the acquittal of the petitioner on the offense under 138 of NI Act.
I am asking you about your interim pair. Is there any interim pair for stay?
Data, yeah, yes, your lordship.
It is not necessary.
Necessary, your lordship.
The learned counsel for the petitioner submits that since the record has been called for from the learned court below, the impugned judgment, the judgment and order of conviction and sentence may be suspended till disposal of this petition. Accordingly, taking note of the submission of learned counsel for both the parties, the impugned judgment and order of conviction and sentence passed by the learned trial court and affirmed by the learned appellate court is then suspended till disposal of this revision petition.
25.
May issue lordship. This is criminal petition under section 528 lordship for quashing the impugn proceeding arising out of lordship PRC case number 281, which is pending before the Blessivara SDGM and Blessivara lordship. But allegation against the petitioner also section 87 BNS as kidnap lordship. Matter was compromised between the parties lordship, and lordship we have annexed the affidavit which is shown by the informant lordship.
Annexer?
Annexer 7 lordship, and my learned friend on behalf of informant he has filed the affidavit lordship. Affidavit in opposition lordship. He has got it lordship affidavit.
What are the sections?
Section under section lordship 87 kidnap and lordship criminal intimidation.
What is the offense under section 87?
87 kidnap lordship, kidnapping lordship.
And 315?
351 lordship criminal intimidation, and 351 3 lordship aggrieved criminal intimidation.
Who lost the FIR?
FIR lost by the mother lordship.
What is the name of the mother?
Name of the mother is lordship and Ranjuma Begum lordship. And affidavit is shown also by Ranjuma Begum lordship.
Where is that affidavit?
Lordship in my petition lordship, annexure 7 page number 37 lordship.
Yes, Mr. Goswami, any objections? Subsit submitted.
Now in lordship, appearance test lordship case.
Under section?
Section lordship. Lordship in affidavit
Yes,
lordship.
you go for the informant.
Yes, you have to think.
So matter has been settled.
Yes, lordship, amicably it was settled in the case lordship. For better of my future, for better bright future of my daughter, I am not interested to. In affidavit lordship, paragraph number 6 lordship, the informant stated that lordship, that after recovering my daughter, I have come to know that the statement of my daughter, she has been love affairs with the question number 1, and according the matter is amicably settled, leadership of the village settlement enters us in view of the amicable settlement and welfare of my daughter lordship. I have decided to not to proceed the case lordship for the welfare of daughter of the informant.
Heard Mr. Alim, learned counsel for the petitioner. Mr. Goswami for the respondent number 2. The respondent number 1. Mr.
MS Model.
Learned counsel for the respondent number 2. Respondent. Informant respondent number 2. In this petition, under section 528 of the BNSS 2023, the petitioner has tried for quashing the proceeding arising out of PRC case number 281 of 2025, arising out of Bilasipara PS case number 66 of 2025 under section 87, 351 within bracket 2, within bracket 3, stroke 3 within bracket 5 of BNS 2023, pending before the Court of Learned Judicial Magistrate, Subdivisional Judicial Magistrate within bracket M, Bilasipara, Dhuburi. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Srimati Reena Begum, within bracket actual name hotel. Where is the FIR?
FIR lordship page number 14 lordship.
The essence of allegation in the FIR is
lordship,
that
19 Banikula. 19 Lordship. Got it, Lordship. সন্মানপূর্বক বিনতি নিবেদন এই যে জুয়া
On-
ইংরেজি মাহৰ সহিংস
No, 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 not necessary. Please sit down. On 25 to 2025 at about 11 a.m. The accused persons, namely Rahul Ali and Azimuddin, have kidnapped her minor daughter while she was standing in front of the house of one Mansura Begum. Learned counsel for the petitioner submits that after investigation, police submitted search. The investigating officer has submitted search against the two petitioners. And the same is pending before the Court of Learned Aziz M. Belasipara for trial. Further, the learned counsel for the petitioner submits that in the meantime, the accused person, the petitioner's hearing, and the informant have settled the matter amicably, and they are no longer willing to pursue the matter before the learned trial court, and that the informant has also filed an affidavit before this court, which is annexed with the petition, annexed with the affidavit in opposition filed by the respondent number 2 as Annexure A. And under such circumstances, further proceeding with the case would be a futile exercise, and therefore it is contended to allow the petition by setting aside and causing the entire proceeding. The learned counsel for the respondent number 2 also submits that the respondent number 2 is not willing to pursue the matter, thinking the better future of her daughter, and also in view of the statement given by her before the police to the effect that she has love affairs with the accused persons. Mr. Goswami, learned additional PP, also submits that state has no objection, that since the parties have settled the dispute amicably, the state has no objection in the event of allowing this petition. Having heard the submission of learned counsel for both the parties, this court has carefully gone through the petition and the documents placed on record, and also perused the affidavit in opposition, especially the affidavit filed by the informant. And it appears that the informant is not willing to pursue the case in view of amicable settlement, and also keeping in mind the welfare of her daughter, and that the case was filed due to misunderstanding between the parties, and the same has been resolved amicably. And now she has no grievance against the present petitioners. Whereas since the matter has been amicably settled between the parties, and since the informant is not willing to proceed with the matter, no purpose will be served by allowing the proceeding of PRC case number 281 of 2025 pending before the Court of Learned Aziz M. M. Bilasipara to go on. And it would be entirely an exercise, a futile exercise accordingly. Taking note of the submission of learned counsel for both the parties and also taking note of the facts and circumstances on the record. And also the affidavit filed by the informant. This court is inclined to allow this petition. The proceeding arising out of PRC case number 281 of 2025, arising out of Bilasipara PS case number 66 of 2025, pending before the Court of Learned Aziz M. Bilasipara stands set aside and quashed.